Mr. Brooks, when you're ready.
May it please the court, good morning. Todd Brooks with Whiteford, Taylor & Preston in Baltimore on behalf of the appellant Danilo Garcia. There are a number of issues on this appeal, and I'm happy to address any questions the court may have, but I want to focus on three issues in particular this morning. The first is some of the more significant evidentiary errors that occurred at trial, all of which the government concedes should be reviewed under an abuse of discretion standard. The second is the government's facially deficient pretrial disclosure. And third, why these errors, among others identified in our brief, are not harmless. Now, the third, fourth, and sixth questions presented in our brief are collectively grounded in Rule 702 and Rule 403 violations. These are among the kinds of errors that courts have identified as risks inherent in dual witness testimony. And so I'll begin with Rule 702 and this court's 2007 decision in Wilson. 702D requires an expert to reliably apply principles and methods in forming an opinion. And so, as a result, we want to see two things in the record. First, we want to see opinions, not facts cloaked as opinions, and I'll get into that in a moment with a few examples. And the second thing we want to see is that every time there is an opinion or a purported opinion, we want to see the reason why the expert reached the opinion that she did. This is precisely one of the errors that the court identified in Wilson, and I'll turn to them both now. First, as the facts cloaked as opinions. Two of the better examples of this are actually right in the government's brief at footnote 8. Agent Dayton decoded the number 145 as 145 grams of heroin. Why? The government explains that because one day after that wiretap call, Walter Powell was caught with 145 grams of heroin. That's not an expert opinion. That's telling the jury what you know about the evidence as a case agent and calling it an opinion. And it's problematic for two reasons. One is that the jury now gets to hear the evidence twice. There's going to be surveillance of Walter Powell being stopped with 145 grams of heroin, and then Agent Dayton is going to take the number 145 and decode it as 145 grams of heroin. And the only reason she knows it is because she was a case agent, and she knows Walter Powell was stopped traveling back on 95 from Philadelphia. And a similar example is in footnote 8. Agent Dayton decodes the number 500 as 500 grams of heroin. And in footnote 8, the government explains that the reason she knew that was because 2 days after that wiretap call, Nancy Feliciano was stopped with 500 grams of heroin. That's not an expert opinion. And we know it's not an expert opinion because even the district court, at the outset of Agent Dayton's testimony, sustained objections that were lodged precisely on this ground and precisely on this basis. And that's in the record at 364 to 68. Agent Dayton tried to decode the numbers 150 and 200. And this issue came up and the court sustained the objection, but that was essentially it. And there are many more examples in the government's brief, in the record, even aside from the examples in the government's brief. But I think the most significant trouble here is that given that the vast majority of her testimony she wasn't actually offering an opinion, she was relying exclusively on what she knew as a case agent. When you look at the record here and you see that the overwhelming majority of her opinions, there is nothing in the record to explain why she reached the particular opinion she reached, that's problematic. And I'm not making this up. This is in Wilson, and this is a quote from Wilson. In Wilson, the decoding expert, quote, offered his interpretation of the meaning of a conversation without offering any reliable explanation as to why he opined that the conversation meant what it did, end quote. But here, unlike in Wilson, where this court looked at the record and said the Wilson expert applied his methods and principles reliably in the vast majority of his testimony, the record here contains no foundation at all for 29 of the 64 opinions Agent Dayton reached about coded words and phrases, and 45 of the 55 opinions she reached about coded numbers. And this is significant because when you look at the instances where Agent Dayton or the government concedes that she only knows how to reach this opinion because she asked someone or because she's relying on what she knew as a case agent, and then you couple that with the fact that 74 of the 119 opinions she offered at trial have no foundation, the error is clear. And the prejudice arises because 54 of those 74 opinions were that some term meant heroin. If you're going to do that, if you're going to offer 119 opinions, 74 of them that don't have a foundation should, and 54 of those should not be that some term is heroin. It's a 702D violation. Now, the second error that the court identified in Wilson as 702A arises under 702A. The opinion should help the trier of fact understand the evidence. And in Wilson, the court described the expert was decoding conversation, clear conversations is the quote. And the government and the district court here, was mindful of this issue. It instructed the government before Agent Dayton took the stand that Agent Dayton's testimony should be limited to decoding, quote, a certain reference that means something that's not apparent on its face, end quote. That's at 328. Now, two noteworthy examples of how 702A routinely was violated. First, as decoded words. On a call played for the jury, Nancy Feliciano stated, quote, the police here got me, and they took the stuff you gave me. Now, an opinion is completely unnecessary for this, because the evidence showed that Nancy Feliciano, in fact, was stopped with a bag full of stuff. It was 500 grams of heroin. And so to take the word stuff and to call that a code for which an opinion is necessary, I just don't believe it. But let me get to the numbers, because when you look at the way Agent Dayton offered opinions about numbers, I think that this becomes a little bit more significant. In Wilson, the court identified a problem where the expert, quote, was not so much interpreting the meaning of coded language as he was adding language to it, end quote. That's in Wilson. On 96 separate occasions, Agent Dayton offered 55 different opinions that a number was a code. The number 125 was decoded as 125 ... grams of heroin. That is precisely what the court identified in Wilson. You're just adding language to a conversation. And it's not just the number 125, which was decoded that way 4 times. She offered 28 different opinions that a number meant a reference to grams of heroin in the exact amount of that number. I won't rattle off a list here, but I will just quickly turn to Rule 403 here, and then I'd like to address harmless error. We all know what Rule 403 allows. It allows a court to exclude relevant evidence if its probative value is substantially outweighed by, among other things, danger of unfair prejudice, needless presentation of cumulative evidence. Through 105 calls played for the jury over a 5-day period, Agent Dayton decoded a term on 294 separate occasions, 119 opinions at all. Now, if you think about the math there's a reason for this discrepancy. 40% of the opinions she offered were offered to the jury more than once. Now, I understand this is a 5-day trial, so that may happen. She decoded the word car as heroin 41 times. Now, just in case the jury wasn't clear that in her expert opinion, car meant heroin, after the 3rd and 4th day of trial, she decoded the term car as heroin 19 times on the 5th day of trial alone. At some point, enough is enough. Now, I think that kind of takes me into harmless error. And I'll just point out that all of the errors we raise in our brief are related to Agent Dayton and the wiretap calls, except, of course, our sufficiency argument as to count 4. But these errors arising out of the wiretap calls and Agent Dayton's testimony are not harmless. And there's two reasons why we know this. One is a legal issue. The legal standard is whether the jury would have been substantially swayed by the errors. And I don't know how they couldn't have been here. It's not a but-for test. And our briefs identify I mean, I read a ton of case law on decoding experts. And what I found is that every case I read, an error that was identified occurred here. So every kind of category I read about, I had here, and not just once or twice, but just numerous times for each kind of error. This is the definition of cumulative error. But the second reason we know this isn't harmless is we look at the record ourselves. And in some ways, I think this case is pretty similar to the Johnson opinion that this court issued in 2010. In Johnson, the government brought in a decoding expert that was never offered under 702, and the court essentially found that there was error because this was a 701 lay witness who was decoding. Essentially, the expert interpreted the meaning of conversations in 4 of only 8 calls in Johnson that concerned Johnson, only 4. And what the court did was it looked at what was left in the record, and it found that there was essentially testimony of 3 admitted drug dealer witnesses who had considerable credibility issues. And the court looked at what was left in the record, and it said, quote, other than the wiretap calls and the testimony on just 4 of 8 calls, quote, or the government, quote, offered no direct evidence that linked Johnson to the charged conspiracy, no drugs were found, no financial evidence was presented, and there was no surveillance that captured Johnson engaging in illicit activity despite the extensive investigation mounted by the local DEA, end quote. So against the backdrop of Johnson, let's look at the record here. There are 5 convictions. 4 of them are possession, 1 is conspiracy. Now, take the 4 possession counts. 3 of them, and this counts 4 through 6, the only evidence that was presented at trial that linked appellant to someone else's possession of heroin once, twice, or 3 times removed was the wiretap calls and Agent Dayton's testimony. So this is precisely what gets us to harmless error in the first place. Count 1 is the conspiracy charge. Now, other than the wiretap calls and Agent Dayton's testimony, there are essentially 2 categories of evidence that would support the conspiracy charge otherwise. The first is the testimony of Yanni Rodriguez. And this is similar to Johnson, where you have an admitted drug dealer who's testifying under a plea deal with considerable credibility issues. And I should also point out, Yanni Rodriguez testifies on the 6th day of trial. By the time he takes the stand, Agent Dayton already offered 111 of her 119 total opinions on 277 separate occasions. And the majority of those opinions were decoding some term as heroin, and the majority of those opinions were infused with 1 or more errors.
I take it you don't mean to suggest, or perhaps you do, that the timing of witness testimony factors into a harmlessness analysis.
I think at least in this case I do. I don't think we need the timing issue. I mean, at the end of the day, the jury's asked to consider the evidence at the end of the trial, and I understand that. But when agents...
Your point is what came before so tainted or rendered largely irrelevant what came after, the harmlessness analysis ought to take that approach.
Absolutely. I don't know how a jury could ever, after hearing improper testimony for 4 straight days, and then again after he leaves the stand, I don't know how a jury could ever fairly evaluate Yanni Rodriguez's credibility and his testimony in general after hearing that. I just don't see it. And so the other category that would support that conspiracy charge is essentially, I suppose, the facts that support each of the possession counts. I already discussed the counts 4 through 6, the 3 of the 4 possession counts, where there is no evidence. I mean, there's this huge investigation. They never spot him on surveillance with a handoff, with drugs. They never stop. So 3 of the 4 possession counts, there is no evidence other than the wiretap calls and Agent Dayton's testimony. Count 7's a little bit different. Count 7 predates the FBI's investigation. And it goes back to April 2009. And essentially, the government introduced evidence that appellant was seen getting off of a bus stop at a Baltimore travel plaza. The police threw their lights on. He turned around, walked back to the bus. The police stopped him at the bus. They recovered a brown bag that they believe he was carrying off of the bus, from the bus itself, and then inside of the bag was a manicure kit. Inside of the manicure kit were what we call fingers of heroin. But this was not a slam dunk charge. Even on this one, the defense brought out in cross-examination the fact that he actually was not caught red-handed. The bag was recovered from the bus itself where there were other passengers. This isn't a case where he walked off the bus, they stopped him, and he's holding a bag. And there was nothing in the bag or in the contents of the bag that actually connect him to it. And there's a few other facts that were presented to the jury. So even on this one, which I would admit is the most significant evidence, other than the wiretap calls, even on this one, there was enough there for a jury to go in a room and have an intelligent, fair debate about whether the government could prove guilt beyond a reasonable doubt. And I just think with the gravity of these errors here, and I realize I'm not going to have time to get to the pretrial, the facially deficient pretrial disclosure. I just don't see how this is harmless error. I can't see it on this record. The prejudice was rampant, and it started from day one of her testimony to the end of it. Thank you.
Mr. Carroll?
Good morning, Your Honor. Please the court. My name is Ayn Ducal, and I represent the United States in this matter. Your Honors, the district court's, the conviction of Mr. Garcia should be affirmed because the district court properly exercised its discretion in denying the defendant's pretrial motion to exclude Special Agent Dayton's testimony. The district court properly exercised its discretion to allow Special Agent Dayton to testify as an expert. And yes, Your Honor, the jury's guilty verdict was regarding count 4 was supported by sufficient evidence. Your Honor, with regard to what Mr. Brooks has just said regarding the length of the trial, I just wanted to correct the record. I don't blame Mr. Brooks because he did not live this trial, but I did, and I recall how much time it took. It was actually a trial that occurred between October 2nd to October 18th, so it was roughly a 3-week trial. I think what Mr. Brooks meant to say was that Special Agent Dayton testified over the course of 5 days. And I would also like to address the harmless error argument, Your Honor. Mr. Brooks has characterized Mr. Yonis Rodriguez's testimony as being that of a cooperator who had credibility issues. I submit, Your Honor, the fact that Yoni Rodriguez testified that he had dealings with Mr. Garcia, the defendant. He testified solely with regard to his dealings with Mr. Garcia, that he sold heroin to Mr. Garcia for resale. He testified that he had, I think, one contact with one of the other trial defendants, Roy Clay, and he had no contact with the third trial defendant, Dennis Ellison. Ultimately, the jury found only Mr. Garcia guilty. They couldn't reach a unanimous verdict as to Mr. Clay and Mr. Ellison. So I submit that the jury clearly found that Mr. Rodriguez's testimony was persuasive.
But isn't this really the kind of case that rises and falls on whether there was error? You know, so many cases are susceptible of a harmless error analysis. But, you know, Mr. Brooks has made the point, and I think it's a pretty good one, and I'm interested in your response. If there is an error in how Agent Dayton testified and her references to items as a matter of expertise, as to words as a matter of expertise that later show up as being part of what actually factually happened in the case, if that was error, it happened again and again and again and again. Now, maybe it's not error, and we want to hear from you on that. But if it was error, I mean, to have the jury exposed to this for 4 or 5 days, how could we ever say with confidence that it was harmless?
I submit, Your Honor, that it was not error, and I will certainly address that. But I take the court's concern that Special Agent Dayton did testify over a number of days. But I would submit, Your Honor, that the fact that there was a guilty finding with regard to one defendant and a inability to reach any type of verdict as the other two defendants gives the court a unique window into the state of the evidence and the jury's thinking here. There was a significant amount of evidence against this defendant, Mr. Garcia, that was not present against the other two trial defendants, specifically, as I've just mentioned, the testimony of Yoni Rodriguez, as well as the testimony of Detective Craig Jester, who recovered the fingers of heroin in April of 2009. And with regard to timing of witnesses, Detective Jester was the first witness in this trial He testified well before Special Agent testified. So I submit that the court's concern that Special Agent Staten's testimony regarding the coded language, any concern that it so infused this trial with error, I think if one looks at the record and one looks at the other evidence that was against this defendant that was not present against the other two defendants, should allay that concern that Special Agent Dayton's testimony, if it was error, which I obviously submit that it wasn't, that it so infused the trial with such error that you could not be confident of the verdict in this case.
Well, what would you say in response to someone who responded to what you just said by saying, well, isn't it just as likely as the jury said, well, we got to convict one of these guys?
I think, Your Honor, that's a cynical view of the jury, and I think that that was not this jury's mindset. I think this jury came to a conclusion that it could come to with regard to one defendant and just simply was unable to come to a conclusion as to...
Okay, so less cynically, I think what you're asking us, or what you're responding, your response to Judge Keenan is, if it was error, then the presence of this witness took the government over the hump on Mr. Garcia, but because that witness had nothing to say about these other two defendants, the government didn't get over the hump. Isn't that exactly what Mr. Brooks is saying? That there was a substantial effect on the jury's verdict?
What I'm saying, Your Honor, is that Mr. Rodriguez's testimony and Detective Jester's testimony and the jury's verdict can provide this court with assurance that if there was error in allowing Special Agent Dayton's testimony, that error was harmless because...
But see, I'm not following that. It seems to cut exactly the other way. If the jury hung on the other two, having heard the same, we posit, erroneous testimony, and you bring in a couple of more witnesses on defendant number one, Mr. Garcia, doesn't that exactly prove that it wasn't harmless? Doesn't that demonstrate conclusively that it's not harmless? Because you account for the difference by just adding a little bit more.
I don't think so, Your Honor, because I think that, so if we say that obviously the common thread for all three defendants was the testimony of Special Agent Dayton. And the concern with admitting her testimony, the concern that has been expressed by this court in Wilson and Baptiste in those cases is a concern about juror confusion. We want to
the concern is jury prejudice, not just jury confusion.
Both juror prejudice and juror confusion. And the jury, if the concern was juror prejudice and juror confusion, then I think that if there had been a guilty verdict across the board, then there would be more of a concern.
Ooh, be careful! You may not want to force that on assistant United States attorneys coming down here to argue.
I'm saying
that harmlessness is more likely demonstrated when all defendants get convicted, when fewer than all of them get convicted.
My remarks are limited to this case, Your Honor.
Are you suggesting that a hung jury means that improperly admitted evidence is by definition harmless?
What I'm suggesting is that...
That seems to be what you're suggesting.
No, I think, it seems to me, aren't you arguing that, sort of you Venn diagram it, if prejudice was the issue, then all three of them are in that circle. But the fact, if that prejudice was so pervasive, then all three would have gone down the tubes. But the difference was, beyond the circle is the plus, those witnesses against this person is made the difference, not the prejudice. Because if the prejudice was then all of them would have been convicted. But that would, the conclusion would be, it's the plus factor that made the difference, not the common prejudice. That's the thing, that's your
Yes, Your Honor, that is exactly my point better put.
Right.
That the prejudice, if there had been prejudice with regard to Special Agent Dayton's testimony, it would have, in this case, I'm not speaking for any other case, but in this case, it would have infected.
And why do you say that? That's my question. Why do you say that prejudice is only demonstrated upon a conviction? Which is what I was saying. You were saying that if there's no conviction, then per se, there was no prejudice. But I don't know that that's true.
I see that what you're saying, that we certainly can't go back into the minds of the jurors.
Did you retry them?
I'm sorry?
Did you retry them?
Mr. Clay was retried, and Mr. Elson pled guilty prior to
Was
the
Mr.
retrial.
Clay convicted?
Yes, he was.
On the same, and so he's going to be back down here on the same record from Agent Dayton?
Special Agent Dayton did testify in the retrial.
And what did you add in his case?
The difference in his case was, I believe that he testified at the retrial.
He testified.
Yes,
So he hung himself, so to speak.
he did testify at the retrial.
I guess what I'm thinking, though, at this point is, why do we want to, if there's error, and we really need to hear from you
Yes.
on that, why do we want to take a chance in trying to figure out what the jury was thinking and whether it was thinking there was, more evidence here, so they must have done that? That's a whole lot of, maybe logical plotting, but when you're talking about somebody's rights of liberty, why do we want to take that chance if the remedy is just do it over again and do it right?
Well, I submit, Your Honor, there was an error, and so I
Okay,
think
why
I
don't
should
you get
address
to
that
that
since
then?
that is obviously, a core concern of the court. First, with regard to her testimony, she testified that she had a methodology. She testified at Joint Appendix 285 that she looks for common terms. She's testified that she looks at the context of the call itself, whether the language makes any sense. She testified at Joint Appendix 839 that she looks at the context of the call and whether it appears they're trying to hide something. She testified at Joint Appendix 891 that she looks at the context of the call and the overall context of all of these calls, take into account the entire investigation. And I submit, Your Honor, that the examples that Mr. Brooks pointed to that were examples of Special Agent Dayton not testifying as a coded expert, when she testified about 145 grams in a call that was in which later on Mr. Powell was stopped with about 145 grams of heroin, and she also testified that 500 was a reference to 500 grams, and then Ms. Feliciano was stopped with approximately 500 grams of heroin. That is what a coded language expert does. The coded language expert, as approved by this court in Wilson and Baptiste, they look for patterns. They look at what is going on in this conspiracy, because it is a conspiracy involving many people. So they have to look at the entire investigation.
Okay, well, how about, if you could help me, this is what's kind of left me scratching my head a little bit. Like on Appendix 924 and 925. 924, she says, when Mr. Garcia uses the term $500, that's code for 500 grams of heroin, okay? But then on 925, she said, he uses the code number 5 to refer to 500 grams of heroin. Okay, so on one page, her expert testimony is that $500 means 500 grams of heroin. Are you saying she's saying it could mean either or?
She's saying that there are different parts of the conversation in which Mr. Garcia used 500 to refer to 500 grams of heroin, and in one part where he used 5 to refer to 500 grams.
And is that because in the telephone call transcript, then Mr. Garcia talks about $500, and then he talks about, I need 5?
Yes, Your
And
Honor.
so she's trying to figure out what that means?
She's trying to interpret for the jury that there are different numbers that are used that are code for the exact same
but
thing.
what suggests that what I don't understand from her expert testimony is how $500 1 minute into the call means 500 grams of heroin, and 3 minutes into the call, 5 means 500 grams of heroin. It just... it seems to me she's just kind of picking and choosing out of the transcript.
I submit, Your Honor, that what she did and what
What
she
is
explained.
expert about that, I guess is what I'm saying. I don't know from the record why that's expert.
Well, Your Honor, if you were to look at that call and hear that call without her expertise, you would just assume that 500 means 500 and that 5 means 5. Her expertise was necessary to explain to the jury that there are two different terms used, two different numbers used to refer to the exact same thing. So I submit, Your Honor, that that is an example where her expert opinion was necessary.
But I guess what's really troubling me is that she's just stating a declaration of opinion based on really the progression of the phone call, it looks like. There's no independent basis why she's saying this is her expert opinion.
She provided throughout her testimony, and perhaps not with every call, but she provided throughout her testimony her methodology, which was her basis. Her methodology being to look for common patterns and to look at the context. As an example, I think you need only look at the chart laid out in defense counsel's opening brief. She identified common words a number of times. She identified cars 17 times, working at least 5 times, at least 8 times. She identified smaller numbers to refer to larger numbers. So while she may not have stated her bases perfectly and at the conclusion or at the beginning of every call, she did do what this court has asked expert testimony to do. She laid out her methodology and she found the patterns that are in each call.
Right, that's the same to me with the Fourth Circuit precedent. Sort of, once they opened the door and said this kind of thing is allowed, she did what all of them do. They use content and context. For example, if you say 500 and you say that means drugs, and if later on before you end you say don't forget the 5, well, it does seem like 500 and 5 are different, but in that context, that 5 was referenced to the 500. I mean, so I suppose your argument is that once you're qualified on that methodology, we'd almost have to find that the court was wrong to make her an expert at all. But the way she does it seems in all these cases I see it, it's the same ones. People say, oh, when did you cook? Well, cook doesn't mean cook. It means cooking drugs. Well, where did that come from? But I'm not arguing with you. I'm just saying that that's, once you go down that line, I don't see how you ever stop from the kind of thing you're talking about. Because you're right, the Fourth Circuit said it's allowed. We've approved that in other cases before. I still don't understand the basis of it, but once you had that genre, what does it end? I don't know.
Well, I think, Your Honor, that in this case, Special Agent Dayton, as I said, talked about her methodology. And I think it's also important to note that there was a lengthy limiting instruction given by Judge Blake in this case.
Pretty confusing, wasn't it?
I
wasn't sure what it meant.
I think, Your Honor, what Judge Blake did convey was that it was up to the jury to decide what value or worth this witness, this expert witness, had, as it does with any expert witness.
How could her expertise help her translate whatchamacallit as heroin? Where's the expertise in that?
The expertise comes, Your Honor, in experiential expertise, in working drug cases, in talking to those involved in the drug trafficking field, in looking at the whole investigation, in looking at the context of the call.
Ladies and gentlemen, that's heroin.
Yes, Your Honor.
Whatchamacallit, ladies and gentlemen, that's heroin.
In this call. As Your Honors well know, drug trafficking code is not the same as, say, Morse code. It's not fixed. It can change it certainly changes from conspiracy to conspiracy, from location to location. It can change within the conspiracy. It can change within the call. It's the definition of a moving target. So it's not possible for Special Agent Dayton or any expert, narcotics code language expert, I would submit in most cases, but certainly in this case, for her to offer sort of a dictionary or lexicon or sort of Rosetta Stone at the beginning. She had to go through each call because sometimes the code words shifted. Sometimes a given code word meant different things. Sometimes girl meant a real girl. Sometimes girl meant heroin. And especially.
And so what is there in this record for this case that was sufficient to establish anything more than, trust me, ladies and gentlemen of the jury, I know this stuff. Trust me. I've been doing this for X number of years. I know how drug dealers talk to each other. Trust me. Where's the testability in that?
I think that,
How could she ever be proven wrong?
Your Honor, she was crossed extensively.
Of course she was crossed.
What I submit, Your Honor, is that she was crossed about the meaning of slang versus code. She was crossed about the way shoes was used she testified that shoes was used in a coded way in one instance and used in a non-coded way in another instance. So she was tested by defense counsel, 3 defense counsel before the jury.
Where is she tested outside the courtroom? Where's the testability of her? Does she go through some proficiency testing? Is there such a thing? If you can answer, yeah.
Yes. Your Honor, there is no proficiency testing for this expert. It is purely experiential, on-the-job training, and possibly some, other more formalized training. But largely, it is experiential.
So we're just sort of stuck with what we're stuck with.
With regard to testing of her, the answer to your question is there's no outside testing as with certification of a scientific expert.
You know, and I understand your point with regard to certain things. Maybe people characteristically talk about heroin as being car and stuff. But, she decoded 53 different numbers. And that's what's really troubling me. She decoded the numbers to mean different things depending on the phone conversations that occurred. And then coincidentally, her interpretations match up with what ultimately was said on the phone calls. She's saying, like here, I wrote one down. She says 2 means 200 at Joint Appendix 600, but the 2 could also be 2,000. She says that at 533. Well, if 2 means 200 in one place, $200, how does 2 mean $2,000 at another place? You see what I'm saying? When it comes to numbers, there's just nothing unique, it seems to me, about her testimony as opposed to car or something else that could be used as a code word. The numbers seem to fit the situation for her.
May I respond, Your Honor? I'd submit that the numbers were code, it was necessary to interpret the numbers because the numbers, as Your Honor pointed out in your prior question, the numbers did not always mean what you would think the numbers would mean. So it was necessary for her testimony to explicate what the numbers in fact meant.
Well, doesn't that just come down to Judge Davis then, what he said? Trust me. This is what I say it is, and I'm an expert. Trust me. How can you test that?
I think you test it via cross-examination by pointing out the ways in which certainly it was inconsistent when she said that 5 meant 500 and 500 meant 500. And she was asked about those inconsistencies, and they were pointed out to the jury.
And she did it again and again. Okay, thanks.
Thank you.
The number 5 actually means 3 things, not to create more confusion. It means 5 grams of heroin, it means $5,000, and it means 500 grams of heroin.
It might depend on the context. That's what she says. She uses pattern and context.
Right.
My question to you is this. I understand your argument, and it's a good argument, a lot of merit, but this panel can't overrule another panel in in a published case, correct? You know that.
That's right.
Right. So this whole idea of, and maybe said exactly that, trust me, but once we said that we allowed this whole genre of you become an expert Because I say the same thing. Where's the college you go to? Where are the classes? But the Fourth Circuit said, yes, you can. After investigating these cases, you become an expert and you can testify. They do that all the time. That's exactly what they do. They said, sugar means heroin. How do I know? Sugar means sugar to me. But they somebody said, that's the same thing. Trust me.
Right.
But why is this not the same thing? This is a trust me case like most of them, isn't it?
Right.
Yeah.
I appreciate that. I'm not here to say that decoding experts, there is no such thing. The solution, quite frankly, and I could write a journal about this, you can't have a case agent be your expert because there is no methodology. You can get up there and say, oh, I've got a great methodology. And when counsel was referring to she has a great methodology, all she did was present the right buzzwords. I look for patterns. I look for context. That's not what she did. She relied exclusively on the record evidence. It's a difference between 702C and 702D. It's a difference of, do you have a proper methodology? If so, check off C. If you don't reliably apply that methodology, you X at 702D. I need to just address a few points. The reason there were different verdicts, there were 210 calls, 211 calls played for the jury. Garcia was on 142 of them. Now, I don't know how many times the other two co-defendants were on them. I would be willing to bet collectively 10. That's why. These are errors. I'm not creative enough to make these up. My day job is the practice of bankruptcy law. I didn't make this stuff up. And when I read Wilson and when I read Baptiste and when I read Ducagini, the Second Circuit opinion, I find myself looking at him and say, these same things happen here, except the frequency is 5 straight days of testimony, not just a few examples, which
you don't object to her being qualified as an expert. Your objection is that she strayed from the foundation, which was the basis of her expertise. You're correct?
Generally speaking, I mean, I don't think she had a proper methodology because at the end of the day, she said the right things. I look for patterns, I look for context. But one thing you also do is confirm your understanding of the coded language used in the case by talking to who? Co-conspirators. So what did you mean in this call? And you ask a co-conspirator what? The moment you have the answer from the person who was speaking, you have an obligation to bring that person into court. And that's the problem here. We know why 74 of the 119 opinions lacked a foundation. Because in the few instances where a foundation came in, the court said, then that's not an opinion. Had the foundation been laid, you'd say, okay, well, where is Diego Amporo? Where is Nancy Feliciano? We need to be able to cross-examine them if that's how you're coming up with these codes. Let me see here. And so the number 145, we know that 145 is not an expert opinion. Suppose you had a battle of the experts. Would 2 experts reach a different conclusion about the 55 opinions she reached about a number? It's not up for debate. You took the facts as you knew them, and you came to the right conclusion, which is why 5 means 3 different things. Thank you, Your Honors.
All right, thank you very much. Yes. Were you a court opponent?
I'm sorry?
Were you a court opponent?
I work for the court appointed attorney. Eric Barron is the court appointed attorney.
Yes.
I've worked on this case with him.
So you're not representing under CJA? I don't want to make it complicated. It's just that. Well, anyway,
pro bono. You're not going to submit
in the interest of covering all territory, we thank you very much for your representation here, whatever it is in terms of that rubric. But we really appreciate that, and we thank you very much, and Mr. Ducal also for the United States. And we're going to come down.